Committee will reconvene. Our second witness today is Mr. Robert Kazami, Director of the Division of Enforcement at the Securities and Exchange Commission. It is committee policy that all witnesses are sworn in, so if you would stand and raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? If so, answer in the affirmative.
I do.
You may be seated. Let the record reflect that the witness answered in the affirmative. Mr. Kazami, you may begin.
Thank you. Chairman Towns, Ranking Member Issa, Congressman Kucinich. My name is Robert Kazami, and I am Director of the Division of Enforcement of the Securities and Exchange Commission. I became Director on March 29th of this year. Thank you for the opportunity to testify on behalf of the SEC regarding Bank of America's acquisition of Merrill Lynch. The committee's invitation asks about the SEC's litigation against Bank of America. Because the enforcement action is ongoing, discussion of certain aspects of this litigation pose a risk of negatively affecting our case. I am happy, however, to discuss elements of our publicly filed court papers. The complaint in our case concerns a November 2008 joint proxy statement that Bank of America and Merrill sent to their shareholders soliciting shareholder approval for Bank of America's acquisition of Merrill. The complaint alleges that the proxy statement violated proxy solicitation provisions because it contained material false and misleading statements. Specifically, we allege that Bank of America represented in the proxy statement that Merrill had agreed not to pay year-end performance bonuses to its executives prior to the closing of the merger without Bank of America's consent. Bank of America, however, failed to disclose that it already had consented to Merrill's payment of up to $5.8 billion in discretionary year-end and other bonuses to Merrill executives. That complaint alleges Bank of America's omission of the information rendering the proxy statement misleading and false. At the time we filed our complaint, the Commission submitted a consent judgment for the Court's consideration under which Bank of America agreed to settle on terms that included payment of $33 million and the entry of an injunction prohibiting it from further proxy solicitation violations. As you know, the judge declined to approve the settlement, and the litigation is thus ongoing. The judge's decision has not affected our underlying case, which is set for trial in March of next year. We stand by our charges and have used the additional discovery available in the litigation to further pursue the facts and to determine whether or not additional claims are appropriate. In determining how to proceed, we will, as always, be guided by what the facts warrant and the law provides. With regard to the proposed settlement, we believe it was reasonable, appropriate, and in the public interest, and also properly balanced the relevant factors that must be considered when assessing any settlement. Where a corporate issuer fails to meet its statutory obligations, the need for deterrence is paramount. The proposed penalty, which would have been the second largest ever imposed in a proxy statement case, would have sent a clear message that proxy solicitations must include the substance of separate non-public documents when the failure to do so results in material misrepresentations or omissions. It also clearly communicated to shareholders and the public that management had failed to keep the company in compliance with securities laws and undercut the position, now asserted by Bank of America, that there was no legal requirement to disclose such information. Importantly, these objectives would have been achieved in a way that did not place an undue burden on shareholders. Although a $33 million penalty is a significant amount, it is not likely to have had a material adverse financial impact on individual innocent shareholders given the billions of shares of Bank of America stock then outstanding. You have also asked why our complaint did not charge individuals. The SEC pursued the charges we believed were appropriate based on the investigative record and applicable law. The securities provisions that govern proxy statements are directed to those who solicit proxies or in whose name proxies are solicited. Here, the corporations solicited the proxies. As such, Bank of America had a legal obligation that we alleged it failed to meet. To establish that individuals aided and abetted a proxy solicitation violation or committed fraud under the securities laws, it is necessary to prove scienter, or knowing or reckless misconduct. Based on the record that existed at that time, we did not believe that we could fairly and properly assert scienter-based charges against individuals under the applicable legal standards. We have followed and will continue to follow any additional evidence developed wherever it leads. I want to be clear that the proposed settlement in no way reflects a change in the Commission's approach to pursuing charges against individuals who violate the federal securities laws. The Commission has been and will continue to be aggressive in bringing actions against individuals who violate the securities laws, and also will continue to vigorously pursue penalties from culpable individuals, including corporate executives. In fact, as outlined in my written testimony, the Commission recently has filed a number of enforcement actions against corporate executives charging violations of the federal securities laws and seeking extensive remedies. Thank you for the opportunity to address these important issues, and I look forward to answering your questions.
Thank you very much. And again, we apologize for the break, but we have to vote around here. So, Mr. Kazami, I know you are currently preparing the case against Bank of America, and I don't want to do anything, say anything that's going to jeopardize your case. But in general, what is the SEC? What do they believe Bank of America did wrong? What do you think happened here that was wrong?
Mr. Chairman, in our complaint, we allege that the proxy materials that were sent to shareholders, which was the basis upon which they would decide as to whether or not to vote to approve the merger, stated that Merrill Lynch could not pay discretionary bonuses without the consent of Bank of America. In fact, what the proxy solicitation did not disclose, that there already had been an agreement that Bank of America would allow Merrill to pay up to $5.8 billion in exactly those kinds of bonuses. So the proxy was misleading because it suggested that no consent had been given and no such bonuses would be paid without such consent, when in fact the consent had already been given.
Mm-hmm. You know, I know you're a very serious prosecutor, and that's what we need in this day and age. What can we expect from the SEC going forward in terms of aggressive enforcement against corporate wrongdoers? What can we expect from this point on?
Well,
we're talking about a lot of money here.
I understand. Look, first I would point to the recent cases that we have brought against corporate executives. In the mortgage fraud area alone, we have charged the CEOs, the CFOs, or other senior executives in New Century, Countrywide, American Home Mortgage, Brook Street Securities. We charged Hank Greenberg and another official at AIG. So just in the recent past, we have gone vigorously after those individuals who we believe were heading companies that engaged in one form or another of fraud or wrongdoing, particularly with respect to mortgage and mortgage-related products. So I think past is prologue, and you will continue to see that kind of approach. Under Chairman Mary Shapiro, we're embarking on a number of internal efforts to streamline our processes and make ourselves more responsive, but we are reinvigorated and rededicated to that effort.
But you do feel that you have the tools to be able to do the job that needs to be done. No legislation or anything is required in order to be able to move forward with this aggressive approach that, you know, the word around here now is robust approach.
Robust, yes, yes. Well, look, we have a number of legislative proposals that we have presented, particularly involving hedge fund registration, the creation of a central clearing party for derivatives transactions, more and better information on exactly the kind of trading and activity that goes on in some of these over-the-counter and opaque markets. In addition, we've sought information, legislation regarding nationwide service of process and some other things to help make our job easier. And lastly, of course, funding is a significant issue. We have, I think the last statistics I saw, over 35,000 regulated entities that the SEC is responsible for, between issuers, broker-dealers, investment advisors, transfer agents, credit rating agencies, and that's before we get to hedge fund registration. And despite those numbers, the enforcement staff is 1,100 total. I think that additional funding would also go a long way toward helping us complete our mission.
All right. Thank you very much, and thank you for your testimony. I now yield to the gentleman from California, Ranking Member Mr. Issa.
Thank you, Mr. Chairman. Mr. Kazami, I know you were not on board on December 18th of last year, but are you familiar with the document dated December 10th, which was delivered to the Fed on that date, which is called the Fourth Quarter '08 Physical, or F, Walk-Down, the so-called walk-down document?
I do not believe I have seen that, Congressman.
Okay, well, let me just, Mr. Chairman, I ask unanimous consent this be placed in the record at this time.
Without objection.
It's already in our information, but I want to make sure it's in the record at this point.
Without objection, so ordered.
And I apologize, it's December 17th, I believe, it was delivered. It would not probably surprise you to know that it actually, on page 6, it lays out those bonuses. Mr. Bernanke, Mr. Paulson had that on those days in December. Had you been in the room when this was delivered, in other words, you, the SEC, would you have then been aware of the failure of the proxy in time to at least begin action at that point in December?
Well, I guess you would have to know exactly what was said in the proxy and then compare that to the information that was then available.
But you knew that. You have compliance people. You are hand in hand, and you get paid to make sure that the public is protected throughout the process of a merger. So let me ask you the real question. We're the Government Oversight Committee, and it's a double entendre because we oversee the government. We're also the government entity that oversees a number of things that are outside the government. But in this case, the Federal Reserve, the Treasury, and the SEC, as I understand it through testimony again and again, the SEC was locked out of this process during that time and did not get into the process until January. Isn't that correct? You were not, your agency was not informed of what the Fed was doing or the Treasury was doing, and you were not at these meetings. You were conspicuous in your absence, right?
I understand that's correct, yes.
So, from a standpoint of the Security Exchange Commission, the respect that Treasury and the Fed should show in the future, shouldn't you be at the table if tens of billions of dollars of taxpayers' money are being thrown in to complete a merger, and at the moment that an executive, a party, says, I'm looking at the MAC clause, I'm looking at breaking up this because things have changed, or things were not disclosed, or we have learned something, wouldn't that, in your opinion, be an absolute mandate for the Security Exchange Commission to be in the room from that time forward?
Well, Congressman, I think if it was a matter that impacted on the SEC's jurisdiction or responsibilities with respect to shareholder disclosure, regulation of the securities markets, the answer would be yes.
Now I'm going to ask you a hypothetical, but it's not much of a hypothetical. If you had been in the room on December 17th, 18th, 19th, if you had been in the room when they said, this is not going to go forward because there have been material adverse effects, and on top of that you were aware of misstatements in the proxy, would you have interjected at least your oversight, your opinion, and your demand that compliance to law be adhered to, which it wasn't?
Well, I mean, I'm not sure that I would have commented on whether or not a MAC clause was properly invoked or not.
Well, but we've already had testimony that if they invoke the MAC, they have to go back to the stockholders.
Correct.
And the Federal Government came in with $20 billion, and there's some debate about whether it was forced on B of A or B of A demanded it. Regardless of which one that is, at that point when there's new money, a MAC clause, or money in lieu of, and on top of that material misinformation in the proxy, shouldn't you be in the room? And more importantly, if you are in the room, wouldn't you have acted to at least advise, and let's assuming you're willing to take on, the Fed chairman and the Secretary of the Treasury, that in fact they're crossing lines at that point that should not be crossed. They are failing to disclose to the very stockholders, the public, that you protect?
Well, if those events triggered a disclosure obligations, we would certainly communicate that.
For Christ's sake, we've had 5, 6 hearings. Mr. Kucinich has dedicated probably a whole wall of his library to this very question, and you're saying if? Let's go back again. They failed to disclose these bonuses. It became aware, the Fed and the Treasury became aware of that. They also became aware that these losses were mounting, and through a negotiation behind closed doors in which you were locked out, they negotiated additional money, now repaid, but additional money to make B of A go through with this deal, or to encourage, or in fact on their demand to have them go through. So all of that occurred with your agency locked out of the room. Are you going to tell me today if there was something to be reported, or are you going to say, like Sheila Bair that was here earlier, yes, I would like to have been in the room, and if I had been in the room, or when I was in the room, I wish I had said or done more? Which is it? Are you going to say the SEC should darn well be in the room and be protecting stockholders, or are you going to say if today? Which one is it?
No, I'm sorry. Perhaps I didn't make myself clear.
I think I did.
Yes, you did, Congressman. Very clear. My only point was that we would certainly like to be in the room anytime there are discussions that go on that affect shareholders and the entities and individuals that we regulate and protect. My only point was a more modest one, whether or not discussions about invoking a MAC clause necessarily trigger disclosure obligations under the federal securities laws.
Thank you. Thank you, Mr. Chairman, for your indulgence. I think we made the point that Mr. Kucinich and I have both been wanting to make, and I look forward to continuing to follow up on it. Yield back.
Right. At this time, I will yield to the chair of the Domestic Policy Subcommittee, the gentleman from Ohio, Mr. Kucinich.
Mr. Chairman, I just want to say at the outset of my friend from California that there is a distinction between what you're discussing and what our subcommittee has been doing. And that is that you're talking about disclosure events that occurred after the shareholder vote. Our focus in this subcommittee has been about disclosure events before the shareholder vote. Now, Mr. Kazami, my subcommittee investigation has found that Bank of America relied on the November 12 forecast for fourth quarter 2008 created by Merrill Lynch that omitted any forecast of how collateralized debt obligations, subprime mortgage-backed securities, credit default swaps would perform in the quarter. The former Merrill CFO admitted to staff that the November 12 forecast was not, in fact, a valid forecast. Bank of America knew at the time that the November 12 forecast was of questionable validity. It's in quotes. However, Bank of America did not do any actual financial analysis to make up for the Merrill omissions. Instead, Bank of America merely pulled out of thin air a number on November 13th, which was recorded on a forecast document as the gut feeling of Neil Coddy, Bank of America's chief accounting officer. The attorneys at Bank of America and at Wachtell Lipton did not question the financial information they were given in spite of the glaring and obvious omission and the explicit reference to a gut feeling. They advised Bank of America not to make further disclosures to its shareholders in advance of the merger vote based on the information in the deficient forecast and a gut feeling. The November 12 forecast omission of any projection for losses in the CDOs and other illiquid investments, and the implication that Merrill Lynch would break even in those investments for the remainder of the quarter, was material to the advice attorneys gave Bank of America. Now, when I asked Ken Lewis about this at our first hearing, he told us he relied on advice of counsel. Protecting shareholders is often, in the final instance, the responsibility of corporate general counsels and their outside counsel. The subcommittee's investigative findings demand the question, where were the lawyers? The glaring omissions and inaccurate financial data in the critical November 12 forecast so obvious that they should have alerted the attorneys to the necessity of a reasonable investigation before making a decision on Bank of America's legal duties to disclose. The apparent fact they did not mount such an investigation makes the decision not to disclose Merrill's losses to shareholders an egregious violation of security laws. Mr. Kazami, in March, GAO issued a scathing report on the effect of Christopher Cox's leadership of the SEC in reducing corporate penalties and formal investigations at exactly the time that the CDOs and CDSs were proliferating. To Chairman Shapiro's credit, she rescinded the Cox policy and she appointed you to reinvigorate the Enforcement Division. Now, I am concerned that one pernicious aspect of the Cox legacy may have survived, the unwillingness to pursue, as GAO wrote, quote, more complicated cases, those with industry-wide implications, in favor of those seen as more routine, unquote. Mr. Kazami, this is the test case. This is the case with industry-wide implications, where what is at issue is the performance of the attorneys in interpreting the nation's securities laws strictly or permissively. Here's the case where the SEC Shapiro breaks with the SEC's Christopher Cox. Mr. Kazami, is the SEC widening its investigation to include the issue of Bank of America's failure to disclose to its shareholders the mounting losses at Merrill Lynch, known or knowable, by mid-November 2008, weeks before the shareholder vote on the merger?
Congressman, we have been and are looking at all aspects of the activity with respect to the proxy statements, including the fourth-quarter losses at Merrill Lynch.
Is that a yes or a no?
That's a yes.
If it's a yes, then the work of this committee has been worthwhile, because you now have a chance to do your job, because we've done ours, and the information that we've uncovered should facilitate your investigation. I thank the gentleman. I thank the Chair. I yield back.
Right, thank you very much. I now yield to the gentleman from Missouri, Mr. Lukemeyer.
Thank you, Mr. Chairman. Mr. Kazami, Mr. Bernanke and Paulson were negotiating with Merrill Lynch and Bank of America. They didn't disclose this. They didn't want to put in writing the transaction they're about to embark on here and about to approve and had been working with. If they did that, that would have been a disclosable event that the SEC would have been able to come in to and be a part of and have some oversight over. What's your opinion of this transaction, how it all happened, and this unwillingness to put this in writing?
Well, Congressman, what the securities law require is that if that understanding had solidified to a material contract, then it would have been required to have been disclosed under what's known as Form A case. So Bank of America would have had to make a disclosure if it rose to the level of an enforceable contract. And, you know, that's...
yeah, but isn't this skirting the law by them saying, we're going to have a little wink and nod agreement here, and let's don't put this in writing, let's all just have a gentleman's handshake on it? I mean, aren't they trying to subvert what really is a necessary part of a transaction? Is it the disclosure to all of the parties involved?
Well, Congressman, it wouldn't be appropriate to comment on my views of that in light of the ongoing nature of the investigation, but certainly there can be circumstances where there is an enforceable contract, even though it's not formally written down, in which case it may trigger the disclosure obligations.
Okay, following along that process, and do you see something that has happened here that you think needs to be changed in existing law? Do we need to have something more clarified by the way that we have these transactions take place so that there is more disclosure?
Congressman, we sort of constantly review our disclosure rules and regulations to determine whether or not more disclosure or different disclosure is appropriate. That process is ongoing now. The Sarbanes-Oxley Act required us to consider more real-time or robust disclosure, and that's a process that continues. We would certainly take the experience here and determine whether or not we should change our rules and regulations appropriately.
Okay, well, you still haven't said, yes, there are some things we need to do, and they are. Can you fill in the blank here?
Well, the question whether or not events such as these should require more affirmative disclosure obligation is something that we're considering. So, for example, contracts or discussions short of a formal legally enforceable obligation, should that be disclosed even though all the terms aren't finalized? Or interim results that may not rise to the level of a material impairment of an asset, which is the current standard, whether or not that should be disclosed. So,
are you currently looking at doing that with your rules and regulations, or do we need to have some congressional action, or what do you think we need to do?
Senator, Congressman, that's something that we look at on a regular basis, and we're looking at now.
Okay. As someone who has gone through this and been in the middle of it, And we're in the process now congressionally to try and do something with this too big to fail situation. What do you see that we're not doing with the legislation that's proposed that you think would be advantageous or would be a big aid to you, or would be something that we could do in the future to mitigate or minimize some of the things that are going on or that have gone on?
Congressman, look, from an enforcement perspective, which is my perspective, transparency and information is critical. We cannot determine if misconduct is going on in markets if we don't have complete and accurate and standardized information about what is going on. So, for example, registration of hedge funds, which would require better reporting and stronger compliance and inspection authority, would be highly beneficial.
Okay, the transparency and the registration that's in the bill right now, does it go far enough? Does it go too far? What's your opinion?
If I might, I'm not sure I understand the full and complete details of what's in the current version of the bill, so if I could have an opportunity to respond to you, I would appreciate that. But the same is true in the derivatives markets. We would like that kind of information. One case we brought, for example, recently involved insider trading, which typically takes place in the equity world, in stocks, was actually going on in the credit default swap market. And yet we don't have nearly the same kind of information in that market as we do in the equities.
Okay. Interesting. Thank you, Mr. Kasami. Thank you, Mr. Chairman.
Gentleman's time has expired. I now call on the gentleman from Baltimore, Mr. Cummings, who's a very active member of this committee.
Thank you very much, Mr. Chairman. And Mr. Kasami, I got to tell you, as I listened to my good friend and colleague, Congressman Kucinich, he said our work is done, and I don't think our work is done. And let me tell you why. As you know, the SEC, in the case of the SEC versus Bank of America, there was a settlement that was submitted to the federal court in New York on August 3rd, 2009. The settlement agreement provided for the Bank of America to pay $33 million in fines for making false and misleading statements and proxy statements to shareholders. Bank of America, of course, told shareholders that no year-end bonuses would be paid to Merrill Lynch executives, when in fact it had been agreed that Bank of America would pay up to $5.8 billion in bonuses to Merrill executives. Putting aside the fact that $5.8 billion was to be paid to the executives of a company that was hemorrhaging money at the time, the decision to settle the matter for $33 million struck many of us as being a perverse outcome. Here was a company with $45 billion in government assistance, $20 billion of which was from this exact deal, and the Securities and Exchange Commission let them pay a fine. And this is the piece that got me. Pay a fine with our money, with taxpayers' dollars. Does this strike you as fair to the taxpayer shareholders? Does it fit your mission of protecting American investors? To me, it's like you find somebody and then take somebody else's money to pay the fine, and I'm trying to figure out, where's the punishment in that? Where's the enforcement in that? I mean, if I'm sitting back, I say, oh boy, I got a great day here, got the public's money to pay the fine, everything's fine, I don't have to pay a dime. And then one of the things that I read about the settlement, once I read about it, I fired off a letter to your Inspector General, David Coates, asking him to look into the settlement. I just read in Mr. Coates' recent semi-annual report to Congress that he is in the midst of this investigation, and I look forward to his conclusions. One of the main reasons I requested the investigation was because I would not be the least bit surprised that in the aftermath of this crisis, that further securities laws violations are uncovered, and the violations may have occurred at a firm that has received government assistance. In that case, what is the calculus that is used to determine how to punish a company without penalizing the involuntary investors in the firm, the taxpayers? And I want you to understand, I'm concerned about when we catch folks, what is the thinking that goes into the process of how to punish them? Because to me, this was not punishment, and I'm glad the judge did reject it. And I know you may not be able to talk but so much about the case, but I assume you can talk about what goes into your thinking as the #1 guy who addresses these issues, and the only person that you answer to is Ms. Shapiro, Mary Shapiro. Is that right? It's you, and then straight up to her. Is that right?
That's correct.
So help me with this. I mean, as a lawyer, I'm trying to figure it. I'm trying. Man, when I read this, I got so upset because I said it makes absolutely no sense. And I know you've got a great answer for me, and I'm waiting to hear it.
Well, Congressman, let me take each of those. First, with respect to the amount of the fine, the penalties that we assess have to be proportionate to the actual wrongdoing that occurred. And here, the wrongdoing was not the payment of the bonuses. That may be excessive and wrong as a policy matter, as a corporate governance matter, as a number of other matters, but from a pure enforcement point of view, the wrong was the failure to disclose to shareholders that they said that they would not pay bonuses without Bank of America's approval when they had already agreed to pay the money. And so the wrong was the deprivation of information to the shareholders in deciding how to vote, not the fact that the amount of money that was paid was illegal or proper in and of itself. So we look at the wrongdoing, which was the process.
Okay, I got that. And they had a duty to disclose. Is that right?
Well, yes, they have a duty to make sure that the statements in the proxy are not misleading. So
right.
The number of 5.8 million or 3.6 billion, excuse me, 5.8 billion, although it was 3.6 billion was ultimately paid, is not, I don't think, the measure of the wrong. The wrong was that they did not tell shareholders who needed all the information they could to decide whether or not to vote. So that was the starting point. Then we look at the amount, and we looked at our precedent. In the proxy violation area, the largest fine that we had imposed was 38 million, give or take or so, in a case involving, frankly, more egregious conduct than this because it involved manipulation of their stock and obstruction and other things in addition to the proxy violation. Next, we try and balance the benefit of the harm, excuse me, the benefit of the penalty versus the burden on the shareholders. So we recognize that penalties that we assessed may come out of the pockets of shareholders who may themselves have been wronged by the conduct. Right. So we try and balance. But we have to still impose the penalties because it sends a strong deterrent message to other corporations and other issuers that this kind of conduct will not be tolerated. The deterrence message is critical. It tells others they shouldn't do it. It says that if you do it, you're going to pay a cost. It incentivizes them to fix their own problems before we come knocking. It allows us to leverage our limited resources so that companies voluntarily engage in corrective measures rather than us having to go to each one of them. The lawyers read these things, the corporate executives read these decisions, they implement changes. So there's many good reasons to have the penalty, but we don't want to burden the shareholders more than necessary. That's a balancing that we look at under our penalty guidelines, and we come to the best determination that we can.
See, my time is up. Thank you, Mr. Chairman.
Gentleman's time has expired. The gentlewoman from California, Ms. Spears.
Thank you, Mr. Chairman. Mr. Huzami, I am deeply troubled by your description of what took place. You said that the bank misled the shareholders. The bank didn't mislead the shareholders. It lied to the shareholders. It was a bald-faced lie. Now, on a proxy statement, if you make a bald-faced lie, I think that you should have a penalty that is so strong that you won't ever do it again. Now, the courts seem to believe that $33 million was insufficient. Who initiated the settlement?
Congressman, this was a settlement that was...
Who initiated it? Did SEC go to the Bank of America and say, let's settle this, or did the Bank of America come to the SEC and say, let's settle this?
I don't know the answer to that, Congressman. Typically, settlements result from both parties coming together and discussing the possibility of
Someone initiates it. And if you don't have the answer today, I would appreciate it if you make that available to the committee.
Certainly.
All right. You based your decision on the fact that there was a precedent where $38 million was fined in another setting. Now, you know that the SEC historically, when you were not a member of the staff, was reducing its enforcement actions dramatically. In fact, a recent GAO study indicated that the enforcement actions had been reduced by some 80% and the disgorgement actions, I believe, by some 60%. Presuming those figures are indeed accurate, I may be off a little bit. You're basing a decision on whether or not to impose a fine on a very anemic SEC that was not doing a good job of enforcing the law. So I guess my real question to you is, if something is substantive, if something is significant, if it is a lie, shouldn't the penalty reflect that? And I'm not accepting the fact that somehow, because there was another fine issued before, that somehow should be a measurement when we know that the SEC wasn't doing its job. And finally, your argument that somehow you've got to balance what happens to the shareholders, if that's the deliberative process you're going to use, then the appropriate fine is never going to be imposed on companies that do, in fact, lie.
Well, as to your latter point, the harm to shareholders who may have been victimized by the wrongful conduct is only one factor amongst 8 or 9 that we take into account, one of which is the importance of the deterrence impact of the penalty. So I don't want to mislead you to suggest that we only look at whether or not there is harm to shareholders. We look at a variety of factors, including, most importantly, the deterrent effect of the fine.
Well, let me ask you this. Based on what the judge has said in this case, if you were to start over again, what would be the fine that you would believe would be appropriate for a proxy statement that had a bald-faced lie in it that shareholders relied on, or prospective shareholders relied on, in terms of purchasing the stock?
Well, actually, Congressman, I think actually the judge's concern, in his opinion, had to do more with whether or not the fine was too high, because he felt that it was falling, the burden was falling on shareholders who had been victimized by the wrongful conduct, not that it was too low. But reasonable minds can have different opinions on that issue. My belief is that the settlement that we struck was fair and appropriate.
So in terms of further negotiations, will there be another settlement offered up to the judge, or will this go to trial?
Matters scheduled for trial in early March, and the case is proceeding.
So there will not be any further settlement on this case?
Well, I couldn't predict the future as to whether or not the case will settle or not. As of now, the case is proceeding in the discovery phase, and it's scheduled for a March trial.
Well, I just want to understand that, could you then go back and negotiate a smaller fee? Is what you're saying that the judge wants a smaller fine imposed? I find that absolutely unbelievable.
No, my only point was in the judge's opinion, he indicated that he was concerned about the penalty because he thought that it was being imposed on shareholders who were victimized by the wrongful conduct.
His opinion was not based on the fact that the fine was too low.
Well, I don't remember whether or not he used exactly those terms, but his point was more that the fine was, sorry to repeat myself, but the fine was falling on the shareholders who were victimized by the wrongful conduct.
Well, or maybe his focus was that the fine should be imposed on the executives who misled the shareholders and maybe have it taken out of their salaries.
He did question why no individuals were charged. You're absolutely right, but he didn't suggest that the fine should be paid out of the pockets of individual or particular corporate executives.
Gentlewoman's time has expired. I now yield 5 minutes to the gentleman from Ohio, ranking member on the subcommittee.
Thank you. Thank you, Mr. Chairman. Mr. Kazami, were you here for Ms. Baer's testimony and questioning earlier this morning?
Yes, I was.
And so you're aware of what she said and confirming what Mr. Lewis had told this committee about the meeting took place in October, 10 days after TARP had passed, where the 9 biggest financial institutions were brought to this town, including Bank of America, told they were now going to have their bank partially nationalized. They were going to have to accept TARP money. They had to sign a form. You heard all that testimony that she gave?
Yes.
And I guess my point is, or my question is, well, let me go back to this. And her testimony to this committee a few hours ago was that that action by the Fed, by Mr. Paulson, by Mr. Treasury Secretary Paulson and Federal Reserve Chairman Bernanke, quote, took her breath away when she saw, you know, what took place at that meeting. So now as we move forward, it seems to me that, you know, I guess your testimony, and I apologize for not being here, was another commitment. You talked about shareholders being misled. But it seems to me that this unbelievable involvement by the government, the email we have that's been part of the record in earlier hearings from Mr. Lacker, Federal Reserve Bank of Richmond, where he talked about the fact they didn't want a disclosable event, so Mr. Paulson, Mr. Bernanke were not willing to put anything in writing about the willingness to help Bank of America with additional TARP dollars. I mean, it seems to me that someone looking at this could say, you know, Bank of America, what was the government's culpability here in running the show and pushing for this deal, particularly Mr. Paulson and Mr. Bernanke? I mean, I assume you at the SEC are looking at, I mean, that has to, in my mind, factor into this whole picture, this whole scenario that we've been looking at now for several months. And any response you would have to all that?
Well, Congressman, as we look at these events, we look at the roles of all the participants that are relevant and all of the facts. So I guess that would be my response.
So, I mean, yes or no, would potential arguments by Bank of America that the bank and its management were not necessarily completely liable because they were acting at the government's directions?
Well, the events that you're talking about, I believe, occurred after the proxy, and so after the merger had been approved. And so the question is whether or not, with respect to the TARP money, whether or not that understanding had become a material contract that had to be disclosed under the 8K rules and regulations.
Okay.
And so that is certainly an issue.
Does the whole, I mean, when did you guys first become aware of what was taking place here, the mounting losses at Merrill Lynch? When did you first become aware of that?
Unfortunately, I wasn't there until March, so I can't, I don't know the answer to that question.
Why do you think, when we have the email saying we don't want a disclosable event, why do you think there was a reluctance by the Federal Reserve to not have information be made known to the SEC?
I probably wouldn't be appropriate for me to speculate about that.
Okay. Mr. Chairman, I yield back.
Thank you very much. I now yield to the gentlewoman from California, Congresswoman Watson.
Thank you, Mr. Chairman, and thank you for this follow-up hearing. We've had several in the past, and after listening to the testimony from the Bank of America CEO Kenneth Lewis, the Federal Reserve Chairman Ben Bernanke, and former Treasury Secretary Hank Paulson, and officials at the Bank of America, there's still strong questions, and I know the intent of this committee through its chair is to get some of these questions answered so we will know really what took place. And we want to hear from you the role of the government and what was played in the negotiations, the quality of the Bank of America's due diligence process, and the motivation behind B of A's attempt to claim a material adverse change, or the MAC, and the adequacy of their disclosure to shareholders. Can you package all that in and clarify it for us? I think this is what, the third or the fourth hearing, Mr. Chairman?
Fifth.
Fifth. Okay. Let us hear how you would describe the roles that each one of these sectors played.
Well, Congressman, as involving some or all of matters that are currently under investigation, I have to be careful about my comments. With respect to the proxy that was sent out in connection with the merger, as we have charged in our complaint, we don't believe that we believe that the disclosure was misleading, because Bank of America did not disclose that they already had an agreement to pay bonuses when they told shareholders that Merrill Lynch would not be paying such bonuses without their consent, but in fact the consent had already been given. That is the case that we charged, and that is the case that is proceeding.
Let me stop you, and I want to query these bonuses. Ethically, I don't see how the bonuses could even be in contention when we are bailing out two big-to-fail institutions with taxpayers' monies to try to capitalize these big institutions so they could save people's homes, et cetera, et cetera. Is a bonus appropriate under the crisis conditions that exist? I just want you to talk about bonuses and then continue.
Well, Congressman, again, from an enforcement perspective, my focus is on what the law requires and whether or not the law has been violated.
Well, do bonuses fall under that provision in the law?
Generally not,
Okay.
except in this situation where they made a representation about what they were going to do about bonuses, and that representation, in our view,
But that was
false.
prior to the collapse, wasn't it?
That was
When people signed their contracts, as I understand, they had bonuses attached in there, but the whole condition has changed now, where they have to comply with the provisions that were in the original agreement.
well, that's correct. The bonuses that were paid in this case were paid, frankly, shortly after the merger was approved. That's correct.
Would you continue on, please?
Well, there's probably not much more. I don't mean to disappoint you, but there's probably not more I would say on that topic. Whether or not bonuses are appropriate and the appropriate level, and the balancing between incentivizing talent and retaining talent versus what's an appropriate compensation is probably something that's above my pay grade.
I've heard that say to retain talent. That really goes beyond, I feel it's so absurd. I don't think at this point that you couldn't find 1,000, or you could find 1,000 people out there with tremendous talent. If that talent goes, there are people lined up. I mean, we are really being hit hard. And I'm talking about my district now, which is Los Angeles, Culver City, Hollywood. And people have lost their jobs in droves, lost their investments. Talent is available, believe me. And so it's a phony excuse. But in putting this all together, I feel there were tremendous failures on all sides. Would you agree to that?
I think there's a lot of blame to go around.
Yeah, and my colleague, Ms. Spears, said it was just downright lies that were given, and possibly it was done so that government could support B of A and give them more support in the merger. So I'm just really thoroughly disappointed that the people who were in place, particularly at the SEC, looked the other way. Thank you. I yield back, Mr. Chairman.
Right. Thank you very much. The gentlewoman's time has expired. I now yield 5 minutes to the gentleman from Missouri, Congressman Clay.
Thank you very much, Mr. Chairman, and thank you, Mr. Kuzami, for being here. Let me, just a couple of questions. At what point should action have been taken to curb some of the activities of the big banks' involvement in the securities markets? There had to be some indication to the SEC that some investment houses were stretched too thin without the proper reserves to cover their risk in this market. Did red flags or alarms ever go off? What did you know, and when did you know it?
Well, Congressman, I didn't arrive at the SEC until March of this year, so that's probably not the right person to ask that question of.
How about the people that you work with now that have been there for years? Did red flags go off for them?
Well, there were certainly systemic risks and a bubble that had occurred in the housing market and elsewhere that resulted in the collapse and the excessive leverage and risk-taking that we saw. It is, what the Commission saw at various points along the way. It's difficult for me to answer that question. We didn't have regulatory authority over certain areas, so it might be better if I have an opportunity to respond to you after today's hearing, so I can give you a more fulsome answer.
I'd love to hear from your colleagues in writing just what alarms went off, or whether the relationship was too cozy with the big banks, that they never wanted to cite them for risky practices. Let me ask you in particular, why did Bank of America get only a slap on the hand when it was cited in 2006 for improperly marketing auction rate security? Why were they allowed to continue these practices of using false and misleading information in selling these instruments? In hindsight, do you think that B of A was given too much leeway?
Congressman, I would have to familiarize myself with that case. I'm aware generally of the auction rate securities matters, but as I sit here, not with the particulars of whatever action may have been brought in 2006. I'd be happy to respond.
Would you respond to us and
Certainly.
to the committee in writing on that issue also?
Certainly.
Okay. Mr. Chairman, I have no further questions. I yield back.
Thank you very much. Before we close out, let me just say, Mr. Kazami, I'm troubled by the question that the gentleman from Maryland raised, Mr. Cummings. First, in terms of, it seemed to me that individual executives, the ones who sign off on the proxy filings, should be the ones that are responsible. So therefore, why wouldn't they be the ones that you go after? You find them, and they, from the personal standpoint, because like you said, they're taking our money and then paying the fine, and I'm not sure that we get to where we need to go with that. And the other thing, that the general feeling is, in terms of the community at large, they feel that the reason the judge sent it back to you is that you were not aggressive enough, that you did not pursue it in the fashion that he felt that it should have been. And of course, that's the general feeling among people, if they say in the street as to what's going on. Now, I don't know whether, that's the case or not, but I do believe that you really need to look at that in terms of, because when I listen to the fact that they're paying with our money, that doesn't encourage, people to do what's right.
Well, a couple of responses. First, with respect to the payment of the fine, obviously, any entity that receives TARP funding or other money still has to pay that full amount back with interest. So whether or not a fine was paid with government money, which can tend to be fungible in an institution, but ultimately they had to pay back all the money that they got from the government with interest. I would just make that point. Second of all, you're right, the judge expressed concern about not charging individuals. We've shown a very aggressive posture of charging individuals, and if you look historically at our cases, the overwhelming number of cases result in charges against individuals and not corporations alone, and I just mentioned some earlier today. But the particular issue in the proxy area is that the proxy laws impose the obligation on the entity whose proxy is being solicited or on whose behalf it's being solicited, and those are the corporations. To charge individuals, you need a higher level of proof. You need to show what's called scienter, or either knowledge or reckless conduct, meaning a significant and substantial deviation from normal standards of care. And it is that difference in the legal standard that makes a difference in how we can proceed. There's a higher burden of proof with respect to the individuals, and our determination, based on the record we had, is that we did not have the basis to charge those individuals. Now, as we get into the discovery process, we may get additional information, and we'll take that into account in making our decision. But I don't want to leave the impression that we do not aggressively pursue individuals. We recognize the deterrent impact of charging individuals. As much as corporate penalties deter people, nothing substitutes for charging individuals, and we do that across the board in many, many, many of our cases.
Right. Yeah, because I'm happy to hear it, because the shareholders are really the ones who suffer in a case like this. Let me thank you very, very much for your testimony, and of course we really appreciate the fact that you come in, that you're here, and that you shared with us. This is the end of many, many hearings that we've had on this, and of course we hope that we will now be able to move and to give the kind of confidence that people really need in order to turn the situation we now find ourselves in around. So I want to thank you again. This hearing is now adjourned.